to the latest Planning Live, which is with the Brodies partners. Today it's Neil and Karen, and we're missing Elaine today because she's unfortunately in a hearing, but we're going to be in for a treat with Neil and Karen, and it's an idea of looking at kind of just chatting about general topics. So I will kick us off. I know I've been busy over the summer with stuff, but what's been keeping you both busy over the summer, Neil and Karen?
Well, I'll maybe kick off. And I think, as with a lot of planning people, battery storage is something that's been keeping me busy. And I'm finding it a bit reminiscent, and this is going back a while, of when waste management, particularly waste transfer stations, became a thing. And as with new types of development coming on stream and going through planning, there's always a period where there's an uncertainty, things go a bit slowly, councils aren't too sure how to approach things, and that certainly seems to be the pattern with a lot of battery storage projects, and in particular an uncertainty about how to interpret policy. And I'm sure we'll talk about MPF4 quite a bit this afternoon because it's such an important topic. One of the things the ministers, it's in the Chief Planner's letter, emphasising you read MPF4 as a whole. You're supposed to read the development plan as a whole, but I've certainly seen, in the context of battery storage, quite a few policy responses which are very much trying to tick every policy box rather than reading it as a whole. And the other thing that I wanted to mention in terms of keeping busy is pre-application consultation. And I find it slightly bizarre that pre-application consultation raises so many legal issues, because it's just about consultation with communities. And it does feel that we've ended up in a situation where we are getting bogged down in details of rules, and more importantly, details of what the rules don't quite say and trying to interpret it, when actually it's quite a straightforward situation, really. As long as the communities are being consulted and it's the two public events and whatnot, I'm not sure that we really need to delve into making it complicated around, what happens in this situation or what happens in that situation. But anyway, it keeps me busy, and I don't see that changing. And likewise with the battery storage, I think there are so many applications either in the system or coming forward soon. That'll be a continuing theme.
I think certainly with the situation on PAC, the changes over the piece have not helped matters. And while now you've got a bit more flexibility in terms of relying on an earlier PAC if you need to come back in, but I think just the sequential changes have perhaps just left everybody somewhat confused about that. But well, in terms of what I've been doing, and perhaps to just provide some BBC balance to Neil's angst about perhaps officers not dealing with things quite in the way that he would have hoped for. I've been quite encouraged by the pragmatic approach that's been taken by planning officers in a few recent cases I've been dealing with. And I can think of one case in particular following refusal of, it was a major city centre scheme contrary to officer recommendation, and on a very tight decision at committee, which I think left clients very disappointed. Officers then were very good in working with our client to enable a very speedy resubmission following discussion on some minor design amendments. And the resubmission was then determined in less than 2 months under delegated authority. So I was very impressed, although we did get off to a shaky start with the refusal, but it was a sort of very positive response from the officers to that situation. And perhaps even better, we've just been successful in appealing the first decision. So the client has now ended up with a choice of permissions, which is nice, although I think they know what one they want to be working with. I was also out earlier this week for day 5 of a CPO hearing. It's been a bit of a mammoth undertaking altogether, involving 2-party litigants. I won't say too much about the detail, but for a sizable project, which often these CPO cases are, it's a reminder of, I think, just how challenging the processes can be for members of the public who are trying to participate, even where the more informal hearing process is used. It's obviously meant to be a bit more user-friendly, but I think certainly was proving a challenge. But the sheer load of papers for those objectors to contend with, I think they were finding to be very difficult, which I wasn't really surprised about. So I don't know what we can particularly do about that, but it's just the system, I think, and speaks to the size of some of these projects. But anyway, it's been a busy summer.
Well, that's good to hear. Thank you very much, both. So just looking at things that have happened or things to discuss, one of the planning headlines over the summer was the outcome of the first local development plan evidence report, gatecheck, which is obviously under the new process for plan making. So could one of you perhaps talk about what was involved in that for those who may not have kind of read more into it?
Yeah, actually hot off the press a day or two ago, it's now 2 decisions, because the first one was for the Fife LDP, but we've also now got Moray, and it's a very interesting compare and contrast in the sense that Fife's evidence report got a thumbs down and Moray's got a thumbs up, and got lots of sympathy for Fife, that it's really hard being one of the first to come forward, because you don't have precedents to fall back on. And I noticed in the DPEA annual report, which came out at the beginning of the summer, they were talking about around 20 evidence reports that they had been told would be coming forward in the next period. I think it was maybe until March. And I'm sure there's a lot of studying going on of the Fife and the Moray decisions, and probably some quite rapid rewriting, particularly on the basis of the feedback from Fife. It's very hard to do any justice in a few minutes in terms of explaining the conclusions the reporter reached on the Fife report. What I've picked out as kind of highlights, the reporter emphasised that she was looking at it in the round rather than picking out individual significant problems, as it were. She did acknowledge that using the further information request power could have resolved deficiencies, but she felt that wouldn't have been enough. And certainly the Moray decision, the gate check process, that reporter did issue, I think it was 4 further information requests. So interesting to see what was involved there. And just to give a flavour of the problems highlighted in the Fife report, issues around transparency of the explanation about the housing supply evidence, insufficient emphasis on the infrastructure baseline, lack of consideration of flood risk and climate change, gaps in the evidence and outcome of stakeholder engagement. So it's picking out a few different things there, and really anyone who's interested, I think you really do need to sit down and read it properly rather than take things from the headlines. Where that leaves matters, Fife have to revise and resubmit. The reporter has provided recommendations, so there's something to build on there, as it were. Murray, their plan was held sufficient, so they get to go forward. And the interesting thing is going to be at the end of the LDP process, so this is projecting a while into the future, or perhaps on the way through, to see what difference this gate check and the evidence procedure has actually made, because it was intended to front load the work and to have that focus on qualitative aspects of the information, in part to try and avoid problems emerging in the examination of the LDP towards the end of the process when potentially it was just too late. And we did have quite a few examples of LDPs that were adopted because reporters had expressed concerns but felt there wasn't anything that could be done that late in the process. So interesting new steps in the procedure, some precedents there for the other councils to build on, still very much an evolving situation and a work in progress. Yeah, lots to look out for in the future.
That's brilliant. Thanks, Neil. So another, I suppose, new thing that over the summer was another aspect of the 2019 Act reforms, which was the introduction of an infrastructure levy. So there was a consultation that was launched on the 3rd of June by Scottish Government. And I don't know whether, Karen, you could give us a summary of the key points from that, have a bit of a chat.
Yeah, sure. And perhaps worth saying just first of all that the consultation is still live. It's open until the 30th of September, so well worth having a look at and responding to if you haven't done so far. It's actually, for all that the consultation has been over the summer, so you might think, well, it certainly justifies a longer period, but I think it perhaps also reflects just the complexity of the issues to do with the levy, which you will see if looking at the consultation. So the first part of the paper gives a pretty good summary of the issues and also the previous pieces of work which have been carried out, because this consultation follows a number of sort of research and discussion pieces that both Scottish Government have carried out, but there have been similar ongoing discussions about SIL down south and what might replace SIL by way of some kind of infrastructure levy. So there's a wealth of, if you like, data and thought been given to matters already. The consultation is pretty open, so asks a lot of questions, as you would expect. Scottish Government does set out its preferred position, but it's fairly high level. I think it's fair to say, rather than getting into detailed proposals, we're certainly not at the stage of consulting on draft regulations as yet. But if the levy is implemented, then there will be no sort of direct impact on development management, in the sense that existing use of Section 75 for developer contributions will continue at the site-specific level. So you're going to end up with that sort of tiered approach. And I think a similar situation exists down south. But the levy would give the opportunity to provide funds for things like strategic transport improvements. So thinking back to the Elsick court case and the troubles that were experienced there, the court said that you couldn't have a fund operating in that way where contributions that were being sought from particular developers, there wasn't a sufficient connection between those developments and the projects to which the contributions were being sought. So that sort of de minimis test that was applied. But the idea is that the levy would help to get round that sort of problem for strategic or perhaps regional infrastructure. So some of the key issues that the consultation is looking at is still a lot of the sort of what, where, how type questions. So what developments would have to contribute? Should it be all types of development? For example, there's a case for renewables development being exempt because obviously it's essential infrastructure contributing to the meeting of the net zero targets. Similar arguments are also made in relation to other types of infrastructure projects. And that might leave us looking at I think they describe it as buildings for people concept in the paper as being the main sorts of developments that would have to contribute. But then you might get into arguments about, well, should housing developments have to contribute because they already deliver by way of affordable housing? Should affordable housing have to contribute? Does that just make it too difficult a prospect? Would that ultimately affect delivery? Then there's the charge itself, which I guess gets you into the more sort of technical nuts and bolts of things. The suggestion is that regulations that might come forward would provide a formula or a framework for working out what the contribution would be rather than containing an amount themselves. So that would be based on some kind of unit or amount per square meter of development rather than being a fixed sum. But beyond that, they look at a number of possible approaches and they all have their pros and cons, whether you're looking at gross internal area, residual value, or something else. And again, looking at the SIL example, that you just get into so much scope for sort of debate and dispute about the way things are set up. Clearly, there's a concern about impact on property markets. So if the levy is ultimately deducted from the land price, then landowners might not be happy to bring their land forward in the first place. If it's paid by the developer, potential impact on viability of developments. So in light of that, Scottish Government really recognised that local authorities will have to have some sort of discretion or flexibility in how they're setting up arrangements for their area, which I think is certainly a good thing, and also recognising local circumstances and areas where really are needing that boost to grow through regeneration perhaps, and where property developments just attract different premiums. So there is a lot in there, and I think still quite a lot to be decided upon. But if you want to scoot to section 9 of the paper, you'll see in a nice summary form just the recommendations or preferred position of the government on those matters.
And it's quite interesting, Karen, because listening to everything that you were saying there, one thing that's coming out for me is actually, although this reform is in the Planning Act, it's not actually anything to do with planning anymore, because the consultation clarifies that Section 75 contributions will continue as is. So, as you said, it's not actually anything to do with development management at all. It only kicks in when a planning permission is issued, but the consultation posing the question of, well, would it be levied at the point the planning permission is issued, when development commences, when development's completed? But irrespective of all of those, it's not actually got anything to do with development management or really planning, and it would be spent on infrastructure. So again, it's as it says, it's an infrastructure levy. It's not really anything to do with planning as such.
I think that's right. It probably ties back more to the discussion we were just having about LDPs, evidence bases, the infrastructure first approach, which comes through the plan, and trying to get all of that right. But you're right, it's not going to feed into the sort of site-specific aspects of particular developments. And other than working out the mechanics of the when and who's sort of for the payment. Interestingly, government I think their preferred position is payment by landowner on commencement of development. But I think the real estate lawyers will have a lot of head scratching to do to work out how all of that is going to be factored into land contracts going forward. So maybe it becomes more of a real estate issue rather than a planner's issue.
That's great. I think it's interesting to see how the development south of the border with their infrastructure levy as well, how they'll kind of compare, I suppose.
Yeah,
Brilliant.
so we have the Georgia should say we have the I think they're calling it ILS and ILE, so that's just plenty scope for confusion.
Yeah, at least all with a different acronym. Brilliant. So next, in July, the Planning and Environmental Appeals Division, or DPEA as we'll refer to it, their annual review was published for 2023 and 2024. I know we've published material on the previous report. So Neil, do you want to give us the highlights of that document?
Yeah, I was amused in that sort of wry way that I was talking to a colleague about DP, and then I stopped and thought, hang on a minute, what does it stand for? And as with so many things, we fire out the acronyms and then completely and utterly forget. So to remind ourselves, Planning and Environmental Appeals Division, so it's all about, for our purposes, planning appeals. They do some environmental ones as well. And there's always interesting comments in terms of trends and things. So I picked out a few. I'm not going to get too much into the statistics. First one I wanted to touch on, there were no appeals, this is planning appeals, determined by inquiry, and fewer appeals determined by hearing compared to last year. And for Karen, myself, Elaine, we cut our teeth in the era when there were lots of PLIs. Hearings were a fairly new thing. And we do, to some extent, look back and sort of think, oh, those were the days. And we've got lots of stories from inquiries in particular. And yes, it was an inefficient process. There were reforms that have helped that. But it is interesting whether the pendulum, as it were, has swung maybe a bit too far in the direction of efficiency, and we're maybe not having just quite enough inquiries and hearings. Although Karen from day 5 of her CPO hearing might not be quite agreeing with that. From a client perspective, hearings and inquiries are expensive or more expensive. So keeping the costs down is potentially an advantage. But there is this point about, are the issues being properly considered? We talk about the penny dropping moment when you can actually visibly see through the discussion at the hearing or an inquiry, the reporter has got a point that clearly they didn't get on the basis of the written submissions leading up to that. And it is interesting looking at the procedure in the Court of Session, where, again, they make much more use of written submissions. And although there is a hearing, it is very much compressed. But the judges clearly still value that verbal opportunity to question and hear some debate. So it's an interesting one. And a slight concern that as experienced people retire, there are less and less people who have experience of planning inquiries in particular, and that could become a bit of an issue.
Next on that point, Neil, do you think, because obviously in England they quite often refer inquiries and hearings and appeals to kind of barristers, do you think that might be, I suppose, with the fear of more experienced solicitors retiring, do you think that might become more of an option in Scotland?
It could be, although the litigation solicitors are in the same sort of situation as the advocates or the barristers, in the sense of, if you don't have the specific experience of the inquiry, you're resting back on the general experience of whatever form of litigation, because it's all kind of roughly the same. So there is that aspect to it.
Luckily for us, we have both.
Well, true. It's also about the experience of the witnesses, because it's not an easy thing being a witness at an inquiry, and it can be very stressful for your first time, maybe your first few times, and that doesn't necessarily help the quality of the presentation if you've got someone who's very nervous. So there's that sort of aspect around it too.
Yeah, it's interesting. You've just mentioned witnesses, because we've just had a question on do you think that the drop in expert witnesses and kind of the cross-examination of those witnesses has potentially, or I suppose could potentially lead to decisions that may be slightly harder to justify from a decision maker point of view if it's purely from a written subs point of view rather than cross-examining an expert witness?
Again, it's an issue of the reporter's understanding of the evidence. I can remember sitting in an inquiry, listening to a reporter interrogating a witness, basically, and the reporter demonstrating a really clear understanding of what the plans, the drawings showed, and really pushing the witness. And that was very encouraging to see that the reporter had such a good grasp of the information. Mm-hmm. And it was a particularly complicated project with a lot of information. But it is still that hesitation of the reliance on written submissions, and is that requiring the reporter to do much more of the work to make sure that they are completely briefed, rather than going to a hearing in session or an inquiry session where the expert witnesses and the qualified professionals, as it were, can help to some degree. But the option is there for the reporters. I mean, that is the guidance, that if they feel that there are issues suitable for hearing or inquiry, then that is the direction for them to go. So it's not really a trend in the sense that that's been the pattern for a few years now, but it'd be interesting just to see if that continues to be the pattern. Another thing I wanted to pick up on, and it's bouncing around quite a lot, short-term lets, Airbnbs, other platforms are available, and the report notes significantly increased numbers of planning enforcement and certificate appeals, and actually, to pick out the number, 156, which in itself might not seem all that much. It's 13 a month, just saying. But the standout is it's 28% of all the planning appeals that DP took that year. So that shows the volume. And I think what it is showing is we've got a separate system of licensing, whether we need to rethink about, does the planning system really need to get involved? Because 156 appeals, you've got all the applications leading up to those. You've got all the planning officer time in the application and the appeal, statutory consultees responding to the applications, reporters dealing with the appeals. It's sucking up a lot of resource at a time when we know the public sector is short of resource. So interesting point there.
Yeah, and I think on that, Neil, I've noticed just in terms of those cases that some of the planning authorities are now starting to seek expenses against the appellants, probably in a way that they wouldn't typically be doing. But I think in cases where they're saying, look, you can see there's been so many, prior cases raising exactly the same points, perhaps in the very same vicinity, and you've still come, you were given a prognosis, and you've still come in with your appeal. So it's perhaps sounding a bit of a note of caution on those cases as well.
And that's interesting, because I wasn't going to mention it, but now that you mentioned it, it's always interesting to look at the statistics and expenses. And because I wasn't going to mention it, I now have to find it again. Although actually, I don't really need to delve into the statistics. I'm still quite keen, though, to find it if I can, because it's not a big report, and it's a really well set out report. So, not finding it. Interesting. Again, the annual report shows not very many expenses claims and not very many granted, which has been a consistent pattern through the years. And certainly that is very much the advice I give to clients involved in the appeal process, that I've had a fair few expenses claims refused when I thought it was actually a fairly robust case. And it does feel that reporters are quite reluctant to award expenses, particularly where the claim is against the planning authority, which is the bulk of them. But interesting your point about the short-term lets, Karen. That's certainly something for everyone to keep an eye on, to see if there's going to be maybe a trend there. Another thing in the DP report, a slightly concerning one, is there's still confusion around which appeal process is correct. And the confusion seems to be because the councils are including the wrong appeal information in their decision notices. And given that we've had LRBs now for quite a few years, it's worrying that this problem is still a problem and hasn't been fixed, particularly when if applicants who have had a refusal leave it a bit late on to submit an appeal, if they've been told by the decision notice the appeal is to DP, and DP take a day or two to tell them, there can be a situation where they're out of time. And legally speaking, there's nothing that can be done. That's a rigid time limit. So it's a concern, but it's also something for everyone who's listening. Just make sure you double check if you've got a refusal and you've got a client who's thinking of appealing, that you have the right appeal procedure in mind, because as I say, some of these decision letters are incorrect. And the final thing I wanted to pick out was just in terms of planning authority performance, there's a fair amount of information in the report in terms of statistics. The one I wanted to pick out, just as an example, really, the returning the PARFs, which the time limit, which is a statutory time limit, is 21 days. And the report shows that 11 of the authorities returned 50% or less. Unfortunately, there were a couple sitting on 50%. So that's why I've got to make it that 50% or less within that 21 days. So there are still problems with delays, even at the beginning of the appeal process, in terms of complying with what is a statutory time limit.
It just speaks to
And
the resourcing issues generally amongst planning authorities,
exactly.
and and it then follows through to often we're seeing that there's really not much of an appeal response, perhaps beyond the initial sort of committee report. It's fairly sort of short and sweet, and I think that's authorities just trying to do what they can.
And it's also interesting, it's the same table, shows the vast difference between authorities in terms of numbers of appeals. There are a lot who only have low single figures in terms of planning appeals per year. And you then get all the way up to Edinburgh Council, who have 138, presumably a large amount of them being short-term lets. Yes. So it's just quite interesting to see in terms of the burden, as it were, on individual authorities, the ones that are having quite a lot of appeals and some that are having very few, and might be interesting to sort of have a think about some of the reasons underlying that, but that's not for a conversation today.
Brilliant. Thanks, Neil. That was very good. Interesting facts in there, and would encourage anyone to go and have a look as well. So the final question, I think we've got time for one more, 7 minutes on the clock. We've had MPF4 now for 18 months. So I suppose looking at the continuing impact, or as it's evolving and how we deal with it, is there any one issue from each of you that you'd like to pick out in terms of what's been interesting, what's been challenging, and how that's played out? So should I go with you first, Karen, because Neil did the last one?
Sure. I know if Elaine was here, she would be speaking about housing for sure, but I think we've had various discussions previously about policy 16F and where we've got to on that. So I think probably the one I would highlight today is the issue of flooding, and that's always linked to when we're thinking about flooding, it's SEPA objections, and just given the challenges I think developers are experiencing with policy 22 and the sort of future-proofing approach that it's taken, obviously building in for climate change, but at a greater level than previously was the case, and so leading to a situation where lots of sites are now being found not to comply with that policy. That's often being badged as a not complying with the development plan. I know it was something that was discussed at the recent SPF meeting that you were at, George. So, I mean, the problem really being, I suppose, twofold. Maybe it's more than twofold, but in the first place, the hard line being taken by SEPA, so which is leading to lots of SEPA objections, notwithstanding mitigation that may be available that can cope with the problems sort of post development. And despite the fact that sites may be allocated, and really that then takes us into a situation where even if a planning authority may be minded to approve the application notwithstanding the SEPA objection, you're then into notification to the ministers and the call-in process. And although a SEPA objection doesn't equate to a refusal, obviously that's not their role, decision remains with the planning authority. Many planning authorities obviously feel constrained almost to treat it as such, and so then not giving that sort of full consideration, reading the development plan as a whole, thinking about development plan compliance as a whole, not to mention obviously the balancing at the end of the day, other material considerations which may still support grant. So giving a positive example, there was the recent case of Kirkwood Homes in Perth, where the council had been minded to grant notwithstanding a SEPA objection, and actually the ministers did decline to call it in, having reviewed the council's reasoning for why it was minded to grant in the circumstances. There were very particular circumstances in that case because there was a live planning permission which would have allowed the site to be built out in any event. But the point really being the council's approach to it and looking at the whole situation and weighing up the material considerations and, sort of the planning balance. And so the ministers really were approving that approach and saying to the council, no, you crack on with it. But then applications going to committee as well, it's perhaps even a more difficult sell to get members to understand that actually a statutory objection from SEPA doesn't mean that their hands are tied. And so that's resulting in a lot of problems at the moment, but there's just that feeling of intransigence in working with policy 22, given the very limited circumstances in which it will support development in a flood risk area. So pass over to you, Neil.
Yep, Neil, your thoughts?
You were referencing specifically MPF 4. Before I get on to that, it'll be very interesting to see once the MPPF in England has been changed, that's at consultation at the moment, the differences it will make on housing, but particularly on onshore wind. As many people know, I always had an interest in onshore wind and a lot of work. So I'm looking forward to getting teeth stuck into a more supportive policy environment in England. MPF 4, to answer your question, rather than it being like question time and I'll ignore what you asked and just ramble on. My MPF 4 pick, biodiversity enhancement, it's getting quite a lot of attention with onshore wind, but it applies to all forms of development. And it's going to be very interesting to see how it continues to evolve, given the lack of specificity, for want of a better way of putting it, in NPF. It's a very broad brush policy. So it's giving scope for differing local approaches. We've got the issue of biodiversity net gain finally coming into effect in England, and experiences from that possibly coming into play in Scotland, and the evolution from Nature Scot looking at a metric, and what difference that might make, although that now seems to be still a fair way off. I think there was talk of it might be March, maybe, before there might even be a draft of something. So plenty of room as applications continue to come through the system for approaches to evolve, and that whole uncertainty. I doubt it's going to resolve, but there might be at least a bit more certainty as more examples come through the system. So that's my one to watch.
It does. I wonder if I could just add on that, Neil. It does sort of feel at the moment that there's probably quite a gulf in approaches between, you're talking about renewables developments and developments that are inevitably sort of EIA developments. And so there's all that assessment work being carried out and the whole professional sort of environmental team looking at that sort of stuff, and it's maybe being approached in a more sort of comprehensive manner, whereas for a lot of sort of urban, perhaps city developments, clearly they have lots of different assessments on lots of different things, but typically not being EIA developments, it does often feel as if planning authorities are willing to take a much more sort of broad brush, pragmatic approach, happy with the green roof, that sort of thing, without, I think, perhaps getting into some of the conceptual difficulties that are rising in the EIA processes at the moment around sort of mitigation, enhancement, etc. So almost like a different approach for different sorts of development.
Brilliant. I will wrap it up there because we're 1 minute over. But thank you. There was obviously a lot's happened over the summer, which is while everyone's on holiday. That's grand. So thank you for everyone for attending. Sorry for those who asked questions we didn't get round to answering them. Obviously, there was a lot to discuss, but yeah, thank you for them, and we can come back to you separately. The next planning live is Thursday, the 26th of September, where we're joined by Beth Gray, who's an associate archaeologist at SLR Consulting, and we're discussing cultural heritage issues in environmental impact assessment. And so until then, we will bid you farewell and have a good evening. Thanks.